ends in 8883. Can you please unmute your device and tell us your first and last name? It's *6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit *6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, Meyer, unlike the paperwork that I've been sent. But it says Myer. It is not me. I am here under duress.
Mr. Meyer? Please
Yes,
stop
ma'am. Meyer, not
Please
the person
stop
you have
talking,
spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the state of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
See what's for the people.
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be
December
coming to your court for any
Then-
fucking reason.
Pardon the interruption, but that kind of language isn't appropriate for a courtroom setting. I apologize for stepping in, though allowing this to continue wouldn't change the outcome that he is still speaking. Yes, but with every word, he's only making his situation worse. The damage isn't coming from the court. It's coming from his own statements to this point. He hasn't finished yet, but the direction is clear. Instead of helping himself, he continues down a path that is steadily working against him.
Bench warrant to issue.
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was
Told
paid
the police
10
that-
years ago
we told
or
the
more.
police that
Now,
once
you can either
before.
fucking listen or we can do this out in front of your court.
Mr.
This
Meyer,
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a
and it will
goddamn
be
tyrant.
recorded. All right.
I called the
60
goddamn
days.
fucking attorney's office and you fuckers rejected me. Are you insane?
3 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
All right.
If she truly planned to support you, any future visits would have to happen at the detention facility, because that's where you're headed based on your own actions. The consequences are no longer hypothetical. They're becoming very real. And regarding those unpaid fines and fees, claims alone aren't enough. If the payments were actually made, the proof would be simple and straightforward. Official records and receipts speak far louder than arguments or excuses. Now that those facts are firmly established, let's turn our attention to Judge Bruni's courtroom. This is where today's case unfolds. Involving a self-described sovereign citizen, he insists he has no obligation to pay child support, arguing that he never entered into a contract with the court. However, as we're about to see, personal beliefs don't override legal responsibilities. especially when the welfare of a child is involved.
Judge, just to let you know, Mr. Smith, it's the middle of page 1.
Yes.
He does not want to deal with me because he does not have a contract with 4D, with any 4D workers. So he doesn't want really to talk to me. He wouldn't talk about the motion. So I'm going to submit a recommendation that the motion be denied.
Okay.
Okay.
It's
He's
not
very
really
difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has, continue to talk about that he's, he has all these constitutional rights, and he's, I don't know, I can't even explain what it is he's trying to get to or what he's trying to talk about. So,
Okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah. You can bring him in. And
I
we'll
can get
address
him.
that.
Yeah, and
Thank you.
so I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him, bring him in.
Thank you.
Thanks.
A motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9 o'clock, and you are before Judge Brolick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 and simplifications. If you can give me a second so I can make it back out to my vehicle so I could hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. Give me 60 seconds. I had to come back inside because whatever just went on.
Hey, Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015. So I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith. I
appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 at 7, Sunday at 7, and you could have additional parenting time, but that's what your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know. This is not a constitutional issue. It's a state law issue, Mr. Smith. And in order for first of all, have you talked with Ms. Zorn this morning? Do the two of you have an agreement? Certainly, if you have the agreement, you know what's best for your 2 children.
Sir,
We do not.
am I
Okay. So, is there any merit in talking, Ms. Zorn and Mr. Smith?
I object. I made my kids in private. I'll raise them in private.
Did you really just argue that because your children were conceived privately, they should somehow be raised outside public responsibility? That statement doesn't actually explain anything, and it raises more questions than answers. Private life choices don't erase legal obligations. Once an issue is brought before a public court, it becomes a matter governed by public law, not personal interpretation. Children are not created in isolation, and responsibilities don't exist in a vacuum. Since more than one person was involved in bringing this child into the world, the law recognizes shared accountability. So, while the argument may sound philosophical, it carries no legal weight. In the eyes of the court, personal beliefs don't cancel duties, especially when a child's well-being is involved.
My kid, this is a non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir?
Absolutely, you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of.
But,
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the 2 parents will talk, and maybe they come to their own agreement, but that apparently is not to be possible
50-50.
this morning.
This is a non-TANF case getting treated as a TANF matter. I want split custody, mutual agreement all Title 4D indemnification ceased and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, under it's not a constitution, under state law, Michigan law, there must be.
I do not acquiesce to state law, sir. I operate on federal law only. This is impeding my rights. I am going to transfer to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pain and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent. I have not consented.
I'm going to state the obvious here. Your actions show that you did, in fact, agree to becoming a parent. That decision didn't happen in isolation, and it involved another person, because more than one party is involved. The law doesn't rely solely on your current objections. Your claim of non-consent is acknowledged, but it doesn't change the legal reality. Once a child exists, responsibility follows automatically. Personal disagreements or revised opinions do not undo obligations that are already in place. In the court's view, accountability isn't optional. The focus is not on what you now claim, but on what the situation legally requires going forward.
Your position is duly noted for the record, Mr. Smith. Mr. Smith,
Thank you.
Under Michigan law, which this court is bound to follow, there must be a change of circumstances that would support a modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody and parenting time today.
I am not here. I'm here to
support. Just file such a motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place into the court all evidence she has partied on my contract. If not, I motion to dismiss with prejudice, failure to state a cause of action. This goes against my Constitution, sir. Yeah, I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate it.
It might be helpful for you to revisit where you learned constitutional law and take a closer look at how those principles actually apply. Some rights are often misunderstood or taken out of context. For example, the idea of facing your accuser is a protection tied specifically to criminal prosecutions. It exists to safeguard defendants when the government is seeking punishment. Child support proceedings, however, are civil matters, not criminal cases. They follow a completely different legal standard and process. While constitutional rights are important, applying the wrong ones to the wrong type of case doesn't strengthen an argument. In civil court, responsibilities are decided by law, not by misinterpreted legal slogans.
Right, to Mr. Smith, perhaps you should consult a constitutional lawyer. This matter is guided by state law. The court has made a decision. There's no change of circumstances that would warrant a change of custody and parenting time. The court will not argue over you, Mr. Smith. So that will conclude, sir. You can zoom out.
Determination of this case.
An order will be entered. All right, Mr. Smith, consultant attorney.
Predetermination of this case, sir.
A quick note of appreciation goes out to Enemy of the State TV for providing this footage. If you'd like to watch the entire video without interruptions, you'll find a direct link available in the description. Now, we move on to the final case featured today. This isn't exactly a sequel to a previous sovereign citizen story, but rather the next chapter in an ongoing situation. The individual in this video was already ruled responsible for a driving-related violation. However, dissatisfied with the outcome of his informal hearing, he chose to challenge the decision. After posting the required bond, the matter advanced to a formal hearing. This is where the case now stands, and where his arguments will be evaluated under stricter legal procedures and standards.
How to initiate traffic stops and what to look for.
Okay, were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay.
Can the court see that?
I can.
Officer Moran, you can see that video that I
can.
pulled up?
Yep.
Okay. Just playing that video now, Judge.
Okay.
Edward John Lincoln, 6501, JL 6501. Yes.
Judge, I'm just gonna stop that video here.
Okay.
If defense would like to play the rest of the video subsequently, we can. I just wanted the court and Officer Moran to see the stop.
All right.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right. So admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling. I wasn't driving.
Ah, I see the argument you're trying to make. You're suggesting that because of how you labeled or described your vehicle's controls, you weren't actually driving. But changing terminology doesn't change reality. A vehicle in motion on a public road, operated by a person behind the wheel, is still considered driving under the law. Courts don't base decisions on creative wordplay or personal definitions. They rely on actions, context, and established legal standards that are so regardless of how you describe the gear selector or the vehicle itself. The legal responsibility remains exactly the same.
Okay, overruled. Go ahead. You can answer the question, Officer Moran.
Yes, I do see the defendant in the court today.
Your Honor, let the record reflect that Officer Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And in that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately, you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him an impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road. So I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Do you guys have that on the record? Did you guys pull that up that I admitted to something?
You'll have a chance
Not,
to.
then that's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
What, just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you. You'll have a chance to testify if you choose to in a moment. Right now, anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right. Well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Moran, or Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay, well, for the record, we don't have any injured parties, correct?
Judge, that's been asked and answered.
Sustained. He already answered that question.
Right, correct. I just wanted to make sure that we got that on the record. So if there's no injured party here, then why are we here?
The reason is simple. A traffic law was violated when the red light was ignored. This wasn't a matter of interpretation or opinion. The officer personally witnessed the violation, and the incident was also recorded clearly on the patrol vehicle's dash camera. With both direct observation and video evidence confirming what happened, the facts are firmly established. This point, the focus shifts from debating technicalities to accepting accountability. The evidence speaks for itself, and responsibility follows accordingly.
No,
Judge, I don't think that's an appropriate question for Officer Moran.
It should have been no type of charge of anything.
Hang on, Mr. Mathis. When there's just like when you made an objection, we all waited for the court to make a ruling. That's what you need to do. So Mr. Klusny just made an objection that your question was actually more of a legal argument. I think that's what your objection was, Mr. Klusny, correct?
Yes, Judge, I don't believe there was a question directed to the officer.
So I'm sustaining that objection. And again, you can make those legal arguments or whatever the case is that you want to make at the end. Right now, it's just questions or not to Officer Moran. Anything else?
No, that's the only question that I have. If there's no injured party, he said no one was injured.
All right. So, Mr. Kaluzny, would you like to call any additional witnesses? I should ask you first, any redirect of Officer Moran?
Not at this time, Judge.
All right. Then any additional witnesses, Mr. Kaluzny?
No, Your Honor.
Mr. Mathis, will you be testifying, or do you have any witnesses that you'd like to call on your behalf?
No, I don't.
So, to be clear, you're presenting no witnesses of your own, and you're also choosing not to challenge the officer's sworn testimony. That leaves a serious gap in your defense. Without evidence or rebuttal, there's nothing to counter what the court has already heard. That IT almost sounds as though the expectation is that the judge will simply disregard the testimony and evidence that were just placed on the record at this stage. That approach doesn't align with how court proceedings work. If anyone can explain the logic behind this strategy, the discussion is wide open in the comments.
All right. Mr. Kaluzny, then your closing statement.
Judge, based on the testimony of Officer Moran and the video, it's clear by a preponderance of evidence that the defendant committed the offense of disobeying a traffic signal. The authority for the stop comes from MCL 257.611 or 257.612. I believe that's for the traffic control device. The video in this case could not be more clear, Judge. You see the Officer Moran is in the left turn lane. He gets a green arrow, and the defendant in his vehicle has a red light, drives right through the red light. If Officer Moran didn't stop, he would have hit the defendant's vehicle because he went right through the red light. It's rare that we have a video that is as clear as this, Judge. And the officer tried to give him a break by writing him for an impeding instead of what he actually did, which was disobeying a traffic signal. And I believe it's clear, based on the testimony in the video, that the defendant is responsible for that traffic offense of disobeying a traffic signal.
Repeat your change.
Yeah. Thank you.
You got the light?
Mr. Mathis, your closing argument?
Well, what I would like to say on the record is no one was injured. There's no injured parties. If you guys can't bring forth any injured party, then why are we still here? I need this to be dismissed, and the funds that was issued on the bond account needs to be reimbursed to me. Period. You guys don't have any injured party here. Based on the Constitution, the Sixth Amendment, if you guys can't bring forth the accuser, then this needs to be dismissed.
Anything else, Mr. Mathis?
Not at the moment.
All right. Was there a bond posted? I'm not quite sure what he's talking
Absolutely.
about.
Judge, it looks like there was a $175 bond posted. Judge, I apologize. The file is here. I'm going to send the file into court.
Mr. Kaluzny, the amendment was to disobey a traffic signal, which is okay.
I apologize, Judge. The file coming into you.
That's all right. The amendment that the people made here was to disobey a traffic signal. Is that correct?
That's correct, Your Honor.
All right. The court's heard the testimony, the arguments of the parties, reviewed the video that was introduced as evidence. The video shows clearly the vehicle driven by Mr. Mathis go through a red light, the traffic signal at 11 in Washington. The standard here at issue is preponderance. The video showed beyond any doubt, really, that that's what occurred. Also, there's testimony from Officer Moran that that Mr. Mathis did actually admit on the roadside that he had done what was alleged to have occurred here today. That testimony was uncontroverted by any other evidence that was introduced. With that, the court does find Mr. Mathis to be responsible for the amended charge of disobey a traffic signal. That's a $150 fine. Mr. Mathis has posted a $175 bond, so the court will apply the bond to the fine of $150. There's a $25 refund coming to Mr. Mathis, and that's all for today.